afternoon, and thank you for all coming. I understand Sergeant Galaviz has explained the rules. I will not be taking any questions, and there's just too many of you to grant individual interviews, in which I wouldn't be able to answer any of your questions anyway. What I'm about to say is governed by Rules 3.6 and 3.8 of the Rules of Professional Conduct. Accordingly, I willingly preface my remarks to say the charges as embodied in the indictments about which I shall comment are mere accusations, and each of the three individuals named are presumed innocent until or unless proven guilty beyond a reasonable doubt. On behalf of my profession, I would appreciate that statement somewhere noted in each of your written or broadcast reports. There are three topics to discuss. First, the indictment of Kevin Bronson and Mark Soto. Second, the indictment of Aaron Rovenstein, currently the sheriff of Kosciuszko County. And third, a document entitled Grand Jury Report and Recommendation. Upon the petition of Dan Hampton, the duly elected prosecuting attorney of Kosciuszko County, Indiana, I was appointed special prosecutor by Kosciuszko Circuit Court Judge Michael Reed on July 24, 2015. I was tasked to investigate matters related to corrupt business influences, also known as RICO, and the alleged intimidation of some citizens of Kosciuszko County. The original investigating agency was the Warsaw Police Department. In a situation like this, when an elected prosecuting attorney is appointed as a special prosecutor for another jurisdiction, the rest of my office is empowered to act under that authority. Thus, Chief Deputy Prosecutor Tammy Napier, and if later directed by me, the other two deputy prosecutors in my office are also authorized to act. You may see in the future any one of us participating in various aspects, including court appearances. The original objective was to investigate the activities of Kevin Bronson. Mr. Bronson had been arrested by the Warsaw Police Department on December 29, 2014, and was being held in the Kosciuszko County Jail since that date on the following charges: dealing cocaine, possession of cocaine, and criminal gang activity. On August 10, 2015, I was appointed special prosecutor on Mr. Bronson's cocaine case, and on that same day, at our request, Mr. Bronson was transferred to the Marshall County Jail, where he has remained incarcerated with the exception of being transported to and from Kosciuszko County to confer with his attorney and to appear in court proceedings related to the cocaine case. The cocaine case progressed with trial preparation until a final plea agreement was submitted to the Kosciuszko Circuit Court on February 22, 2016. A sentencing date is set for March 8, 2016. As previously mentioned, the original investigating agency was the Warsaw Police Department. At the request of the Warsaw Police Department, the Indiana State Police had been assisting the Warsaw Police Department with specialized investigative resources based out of Indianapolis. Eventually, though, I requested the Indiana State Police investigative assistance independent from Warsaw Police Department efforts. On October 23, 2015, I formally requested the Kosciuszko Circuit Court to impanel a grand jury. Judge Reed granted the request, and the grand jury, consisting of 6 randomly selected citizens of Kosciuszko County, plus 1 alternate juror, began its work on December 14, 2015. On December 16, 2015, the grand jury issued what is called a true bill, which is also commonly called an indictment. At our request, the indictment was sealed from public disclosure and inspection until further order of the court. The grand jury was then adjourned and ordered to reconvene on February 22, 2016. The December 16, 2015 indictment was unsealed today at 8 a.m. at our request. This indictment names Kevin Bronson and Mark Soto. It is in 10 counts, the first 6 against Mark Soto and all 10 against Kevin Bronson. It is now a public document and you've been given copies. I'm going to repeat the admonishment again. The following are mere accusations, and both Mr. Bronson and Mr. Soto are presumed innocent until or unless proven guilty beyond a reasonable doubt at a later date. The first 3 counts are each based upon different sections of the Corrupt Business Influence Statute, also known as the state version of RICO, Racketeer Influence and Corrupt Organization Act. All of the activities are alleged to have occurred in Kosciuszko County. Count 1 alleges that between October 16, 2012 to May 19, 2015, Kevin Bronson and Mark Soto received money from various individuals that was derived from a pattern of racketeering activities, specifically a pattern and series of acts of intimidation, and that Kevin Bronson and Mark Soto used and invested those proceeds to operate an enterprise named Young Dragon Enterprises, LLC. These allegations are a Class C felony and a Level 5 felony. Count 2 alleges during the same time period, Kevin Bronson and Mark Soto, through a pattern of the same racketeering activity, that is a pattern and series of acts of intimidation, that they maintain control of the enterprise of Young Dragon Enterprises, LLC, a Class C felony and a Level 5 felony. Count 3 alleges that Kevin Bronson and Mark Soto were associated with Young Dragon Enterprises, LLC, and they both conducted and participated in the activities of that enterprise through a pattern of racketeering activity, that activity being a pattern or series of acts of intimidation against various individuals. The remaining 7 counts are each under the statute defining and prohibiting intimidation, which, depending on the date of the alleged offense, is either a Class D felony or a Level 6 felony. Count 4 alleges from June 2, 2011 to May 19, 2015, Kevin Bronson and Mark Soto communicated threats to David Baker with the intent that David Baker engage in conduct against his will, specifically to provide extensive legal services, including the preparation of documents aimed at securing a movie contract and or a book contract without payment, or that David Baker be placed in fear of retaliation for a prior lawful act, that is, declining to provide those legal services, and the threat was to commit a forcible felony, specifically beatings or the killing of David Baker or members of his family. Count 5 alleges Kevin Bronson and Mark Soto communicated threats to Nate McLaren with the intent that Nate McLaren be placed in fear of retaliation for a prior lawful act, specifically asking for contact information of Kevin Bronson's superior in the Aryan Brotherhood, and to thereby cause Nate McLaren to engage in conduct against his will, specifically to have his family transported from their home in the middle of the night to a place of safety, and to remain awake in his home to await the threatened commission of a forcible felony, specifically the beating or killing of Nate McLaren or members of his family. Count 6 alleges Kevin Bronson and Mark Soto communicated threats to Nate McLaren with the intent that Nate McLaren engage in conduct against his will, specifically to secure periodic payments from Tyler Silvius to Kevin Bronson and Young Dragon Enterprises, LLC, totaling $84,012.50. It is alleged those payments were intended to prevent a threatened forcible felony, specifically the beating or killing of Nate McLaren or members of Nate McLaren's family. The remaining 4 counts, all intimidation, apply only to Kevin Bronson. Mark Soto was not involved with these allegations. Count 7 alleges that on December 31, 2013, Kevin Bronson communicated a threat to Brian Hickerson with the intent that Brian Hickerson engage in conduct against his will. Specifically, he had his daughters pack their personal belongings to be ready to leave their home on a moment's notice, while Brian Hickerson stood guard the entire night, the threat being the commission of a forcible felony, specifically the beatings or killing of Brian Hickerson or members of his family. Count 8 alleges that in November and December 2014, Kevin Bronson communicated a threat to Corey Green with intent that Corey Green engage in conduct against his will, specifically to provide payments totaling more than $500 to Kevin Bronson, and the threat being the commission of a forcible felony, the beatings or killing of Corey Green. Count 9 alleges in November 2012, Kevin Bronson communicated a threat to James King with the intent James King engage in conduct against his will, specifically cash a check made payable to James King for construction work completed and to return or kick back cash to Kevin Bronson, a substantial portion of the proceeds of that check, with the threat being the commission of a forcible felony, specifically breaking the legs of James King. Count 10 alleges that from March 18, 2013 to February 2015, Kevin Bronson communicated threats to Dr. Stephen Holler with the intent Dr. Holler engage in conduct against his will, specifically to perform professional dental services without payment, with the threat being the commission of a forcible felony, specifically the beating of Dr. Stephen Holler. This morning, with the unsealing of the indictment, the Kosciuszko Circuit Court ordered the issuance of a warrant for the arrest of Mark Soto and set bond in the amount of $10,000 corporate surety. I've been informed Mr. Soto has been arrested. Also issued was a warrant for the arrest of Kevin Bronson and bond set in the amount of $50,000 corporate surety. I have not been informed of a date for the initial hearing of either individual. As I stated earlier, the grand jury reconvened on February 22, 2016 and issued a true bill on February 26. It also issued a document entitled Grand Jury Report and Recommendation. Those two documents were ordered sealed upon the state's motion. I also requested unsealing both documents at 8 a.m. this morning. The Kosciuszko Circuit Court ordered the unsealing of the indictment, but not the grand jury's report and recommendation. The February 26th indictment is in 10 counts against Aaron Robenstein. Again, these are merely accusations of Mr. Robenstein is presumed innocent until or unless proven guilty beyond a reasonable doubt at a later date. Count 1 as a Class C felony charges bribery and alleges on or about March 11, 2011 to June 30, 2014, Aaron Robenstein, a public servant, agreed to accept property from Kevin Bronson, specifically $10,000, with the intent to control the performance of an act or acts related to his employment or function as a public servant, specifically granting or permitting special privileges to Kevin Bronson while an inmate at the Kosciuszko County Jail, and or to Mark Soto, a visitor to the Kosciuszko County Jail, in contravention of Kosciuszko County Sheriff Department policies and or Indiana law. Count 2, covering a different time period of July 1, 2014 to July 19, 2015, charges bribery and alleges Aaron Robenstein, a public servant, agreed to accept property from Kevin Bronson, specifically $10,000, with the intent to control the performance of an act or acts related to his employment or function as a public servant, specifically granting or permitting special privileges to Kevin Bronson while an inmate at the Kosciuszko County Jail, and or to Mark Soto, a visitor to the Kosciuszko County Jail, in contravention of Kosciuszko County Sheriff Department policies and or Indiana law, and or permitted and or authorized unrecorded telephone calls by Kevin Bronson and or unrecorded or unsupervised visitation between Kevin Bronson and Mark Soto. Count 3 charges bribery, a level 5 felony, and alleges from July 20, 2015 to August 10, 2015, Aaron Robenstein, a public servant, agreed to accept property from Kevin Bronson, specifically $20,000, with the intent to control the performance of an act or acts related to his employment or function as a public servant, specifically permitted and or authorized unrecorded telephone calls by Kevin Bronson and or unrecorded and or unsupervised visitation between Kevin Bronson and Mark Soto. Count 4 charges intimidation as a level 6 felony and alleges that on August 14, 2015, Aaron Robenstein communicated a threat to Paul Heaton, a law enforcement officer with the intent that Paul Heaton be placed in fear of retaliation for a prior lawful act, specifically initiating a criminal investigation of the conduct of Kevin Bronson while Kevin Bronson was incarcerated in the Kosciuszko County Jail. Count 5 is charged as assisting a criminal, a level 6 felony, and alleges that from March 20, 2015 to April 9, 2015, after being informed on March 20 that Kevin Bronson and Mark Soto were the subject of a criminal investigation and were persons who had committed a crime, Aaron Robenstein assisted Kevin Bronson and or Mark Soto by continuing to permit and or authorize unrecorded telephone calls by Kevin Bronson and or unrecorded and or unsupervised visitation between Kevin Bronson and Mark Soto with the intent to hinder the punishment of Kevin Bronson. Counts 6, 7, 8, 9, and 10 all charge the offense of official misconduct. Count 6 being a D felony because of the date. The rest are level 6 felonies because of the date. Each count is related to the offenses as alleged previously in counts 1, 2, 3, 4, and 5. They are significant counts because the allegations are all related to offenses committed in the performance of his official duties as a public servant. For example, count 8 alleges that on August 14, 2015, Aaron Robenstein, a public servant, committed an offense, to wit, intimidation in the performance of his official duties as a public servant. I don't think it's necessary to repeat each of the additional counts. They just refer back to the counts 1 through 5. Upon the unsealing of the indictment this morning, Judge Reed ordered the issuance of a warrant for the arrest of Mr. Robenstein and set bond in the amount of $10,000 surety. In accordance with the previously reached agreement, Mr. Robenstein surrendered without incident to the Indiana State Police and was booked into the Elkhart County Jail pending the posting of bond. I understand he has made that bond. I have not been informed of the date and time for an initial hearing. The third matter I wish to discuss briefly is the grand jury report and recommendation. That document remains sealed, although we requested it be unsealed with the indictments. We will renew in writing the request to unseal after my office has had more time to research the legal issues involved. I submit, however, for a grand jury to prepare and file a document entitled Grand Jury Report and Recommendation is, in my experience, highly unusual. It would be fair to assume the document contains matters of vital public concern to the citizens of Kosciuszko County. We will seek to have it unsealed through the proper legal channels. I challenge you, members of the media, to do the same. Thank you all for coming today.
Who will be the next interim sheriff? And who gets the interim
I have
sheriff?
no idea.
Why did you show us that film in the beginning?
Okay, ladies and gentlemen, that concludes today's press conference. I want to thank you very much for your time. The Indiana State Police also will not be speaking on behalf of anybody with respect to this case. This case has been concluded on our end, is now in the hands of Mr. Chipman and his office. So thank you very much. Safe travels back to your home cities.